I'd like to welcome you all to this afternoon's Mind Your Business chat session. It's the first that we've had in a while, so thank you for your time this afternoon. My name's Rachel Altair. I'm the Business and Industry Officer with the Economic and Development team at Melton City Council. And today we'll be presenting David Weems from the Victorian Chamber of Commerce and Industry to discuss anti-bullying, a practical perspective. Will be about a 40-minute presentation with some time for questions and answers afterwards. I'd like to introduce David. He's actually a lawyer by training, but he assures us that he's still a good person. So from what I've understood and how I've met him, lovely person. So don't take that against him. David has worked in private legal practice for 6 years, advising some of Australia's best known brands, including the AFL, Holden Special Vehicles and Cricket Australia. David has also worked as an in-house generalist, privacy and employment lawyer for the Telecommunications Industry Ombudsman, Monash University and the healthcare company Bupa. So I'd like to take this opportunity to welcome David and thank him for his time today.
Thanks, Rachel, and thank you for having me. As we'll see when I move through the presentation, one of the most important things when we're thinking about how to prevent bullying is to take a proactive and front foot approach. And it's fantastic that Melton has made this presentation available and that you've all decided to join today because, as we'll see, training is one of the best things we can do to prevent bullying in the workplace. So thanks for the opportunity and thank you all for joining. We were just talking before about what a typically Melbourne day it is, starting with sunshine and then moving into hurricane force winds, and hopefully none of us drown by the end of the day. So I'm sure the weather is the same and different wherever you are. As Rachel said, I'm from the Victorian Chamber of Commerce and Industry. I'm what's called a senior workplace relations consultant. And basically what that means is I help small businesses deal with their employment and industrial relations challenges. And as we'll see, one of those is how to prevent bullying in the workplace and how to deal with it when we are confronted by it. A couple of housekeeping matters up front. I understand that today's session is going to be recorded. So unusually for me, I'll ask you to hold the questions till the end, just for the purposes of the recording. Normally, I like to keep things organic and say, jump in, shout at me if you've got a question, throw things at your screens and interrupt me. Not like that today, just for the purposes of keeping the recording coherent for people who are watching later, but we will have plenty of time at the end for questions. I do have some disclaimers to give you. It wouldn't be a presentation from an ex-lawyer without some caveats, disclaimers and carve-outs. We've done everything we can as the Victorian Chamber to make sure that this presentation is up to date, but anybody who subscribes to the Workplace Express newsletter service about employment law changes in Australia knows this area moves faster than just about any other area of law. So we do everything we can to keep it up to date, up to and including me reviewing the presentation about 37 seconds before I joined today, but occasionally things do change literally while I'm talking to you. So just important to bear that in mind. We've done everything we can to make sure it's accurate. And what I'm doing here today, even though I was a lawyer in the past, is not providing you with legal advice. I can't answer the old hypothetical questions for a friend. I can ask you things just generally that you might want to know about bullying, but this isn't the forum for me to try and give you advice about problems you might be facing in your workplace. Rachel will share some information about how you can get in touch with us later on if there is something that you do want to talk about, or if you've got a question that you don't feel comfortable talking about in front of this wider group of people. A personal disclaimer from me that doesn't appear on the slide. There's a few more words in this presentation than I'd normally like to use. The reason for that is that we are recording the session, so I'd like it to be able to stand on its own 2 feet without me being here to explain any strange memes or pictures that I might have used as a pictorial representation of the points I'm trying to make. So forgive me for the greater than usual number of words in the slides. Also, this stuff can be pretty heavy and confronting material. So if at any point you do feel like you want to take a break or dip out, if something is sort of resonating with you in a negative way, please just feel free to mute, walk out of the room, whatever you need to do. Because as I say, this stuff can have pretty serious consequences for the people involved. And we will be talking about some practical examples today of how bullying has played out in the real world. So without any further ado, let's launch into the subject matter. What we'll be talking about today is really 4 key things. What is bullying? And importantly, what it isn't. We'll be talking about Brodies Law, which is a subcategory of law that we have in relation to anti-bullying. And it's really important for a couple of reasons. One is it's an example of the worst possible kind of bullying behaviour, so a useful practical illustration of what we're talking about. But it's also among the most serious consequences for organisations that get this wrong. And it's always important when you're thinking about your risk profile as a business, what happens if we get this wrong? Why is this so important? I'll take you through some other examples from the real world, because I think it's always useful to bring the theory to life with some cases. And I'll give you some practical tips at the end about what to do with all of this stuff and how to implement it in your workplace. And as we've said, there'll be plenty of time for questions and answers at the end. A little bit about the Victorian Chamber of Commerce and Industry before I get into the material. A lot of people are surprised, including me when I joined, about exactly how broad the services that we offer are. We do training, the things that you're here to learn about today, and a range of other training services. We also offer workplace relations and occupational health and safety consulting. So we'll come out to you, or not so much these days, we'll listen to you on the phone and help you work through your OH&S and workplace relations problems. We also have an apprenticeship service to help people gain access to all of the supports that are available from the Commonwealth and state governments in relation to taking on an apprentice at work, because there can be a long and exciting range of paperwork you've got to fill in, and it's important to get that right to make sure that you get the most out of the government that you can. We also have an interesting practice in international trade, which I was really surprised about. We do a lot of work in relation to certificates of origin for foreign countries. So putting that Made in Australia stamp actually comes with some rigour to make sure that things were made in Australia. And we, in the time of the Olympics, do a thing called carnets, which I was interested to hear about, which is about taking goods into a country and getting them back out again without having to pay tax. So things like cameras and that sort of stuff. The thing you might be most familiar with us about at the moment is our policy advocacy work. You might have seen our CEO, Paul Guerra, in the media or read some of his articles pushing for policy changes that might assist our members, particularly during these challenging times we find ourselves in with the COVID. So that's us. So what is bullying? At the outset, it's really important to note that bullying is just one of a suite of considerations for employers in a broader sphere of things that we generally refer to as equal opportunity. So there are a range of obligations that overlap in this space, such as discrimination, general protections under the Fair Work Act, your obligations to make reasonable adjustments to support people who have a disability. So I might be talking about an example and you might go, hang on, isn't that sexual harassment? And you'd be absolutely right and you'd get full marks for that. But today we're just here to talk about bullying. So important to keep that in mind. Helpfully, the Fair Work Act 2009, which is the Commonwealth legislation that generally governs work in Australia, has a technical definition of what bullying is, and it's worth reading it out. And we'll unpack some of these key terms in the next couple of slides to kind of bring this to life, because legislation is pretty boring, right? And often it doesn't make a lot of sense in practice until you look at each of the words and think about what it actually means. So the Fair Work Act says a worker is bullied at work. That's an important term we'll come back to. While the worker is at work, another important term, in a constitutionally covered business, that's basically saying a business that's covered by the Fair Work Act, generally a Pty Ltd company like most of you here today would be operating under. If an individual or group of individuals repeatedly, that's a really important word, behaves unreasonably toward the worker or a group of workers of which the worker is a member, and that behaviour creates a risk to health and safety. So that's what bullying is, and we'll unpack each of those important elements in just a moment. Really important to note, that little subsection 2 at the bottom there. To avoid doubt, subsection 1 does not apply to reasonable management action carried out in a reasonable manner. We'll talk about what that means, but basically there's nothing in the Fair Work Act that prevents you from managing your staff. And the type of claim that we sometimes see in the bullying space is somebody who has been performance managed because they're not quite up to scratch. They'll quite often say, you're bullying me. The Fair Work Act says no, as long as you as an employer carry out that action in a reasonable way, and it's reasonable for you to do so, that won't be bullying. And we'll talk about what that means, because only the lawyers really understand what reasonable means. So the first key term here is at work. What does it mean to be at work? There's the obvious and garden variety definition of at work. I'm actually physically at work in my workplace. But the definition under the Act is a little bit broader than that. So in the case of Bowker, which I refer to there in the slide, the Fair Work Commission said being at work is not just confined to the physical workplace. A worker is going to be considered to be at work at any time they perform work, regardless of their location and regardless of the time of day. Does that ring any bells for anyone? Regardless of location, regardless of time of day? We're all living in this new world of work at the moment. So it's not just physically at the workplace where this stuff will apply. It's also at home when people are working at home. So that's why it's really important to kind of refresh your understanding of bullying and sort of think, okay, I'm used to managing this stuff in a physical workplace. I now have many physical workplaces spread around the area. So the focal point of at work is the aggrieved worker and not the perpetrators. In this particular case, these comments were made in 2014 on Facebook, but they're still relevant to us now, as I said, given that we're all working virtually. These bullying comments were made on Facebook, and it was alleged here that the worker had to be at work at the time the comments were posted. And here the Fair Work Commission found that that wasn't right. What happens when you post something on Facebook is that bullying conduct continues for as long as the comments were on Facebook, and it's enough that the worker accesses them at any point they're at work. So important to note here, not a physical workplace, and cyberbullying can be captured by this definition as well. In that Bowker case, the Fair Work Commission also said that sometimes whether the worker is at work will depend on the context, including the custom and practice of what normally goes on in the particular workplace. So for example, in most cases, a phone call from a supervisor outside of hours about work-related matters is usually going to be considered at work for the purposes of bullying. So if you call your staff member and they're in the car on the way to pick up the kids and you talk about work matters, this stuff will apply there. The next key concept we need to be aware of is that the conduct has to be unreasonable. The people engaging in the behaviour have to behave unreasonably. And that's a legal test. And basically, it's an objective test. Whether a reasonable person would believe that this behaviour is unreasonable looking at the circumstances of the specific case. That really means nothing until you start thinking about the types of behaviour that have found to be bullying in the past. And it's really useful to walk through these different examples here from the Mac case, which is a Fair Work Commission case from 2015. I should just pause there and say some of these cases have pretty weird names, and that's because the Fair Work Commission lets people remain anonymous or use a pseudonym to protect their identity, because obviously bullying behaviour can be quite concerning for people and they don't want to let the world know that they've experienced it. So some of the case names you might go, huh, what does that mean? That's why they have some strange names. So the types of behaviour that can constitute bullying are as broad and varied as you can imagine, and they're listed there on the slide. And I won't go through all of them, but some of the ones worth calling out are victimization. So if somebody has spoken up and made a complaint at work, victimizing them in relation to that might very well be bullying. Isolation is an interesting one in that people don't often associate isolation with bullying, but when you're thinking about inviting a whole heap of people out to lunch, think about the consequence of leaving somebody out. That in certain circumstances could be bullying, provided that we meet all of the other aspects of the definition, which I'll come to. Bad faith is an interesting one as well that really doesn't make a lot of sense until you think about what bad faith is. I like to think of it as malicious lying. Things like the boss said, don't come into work today, when you know very well the boss said no such thing and you're just trying to get the person into trouble. That can constitute bullying. So really a broad range of behaviours, and it's broader than everything that's set out there on that list. So really any kind of behaviour at work does carry a risk of bullying, provided it meets all of these tick boxes, if you like. One of the other things that we need to tick off, if you like, for behaviour to constitute bullying is that the behaviour has to represent a risk to health and safety. So there are a couple of things there. The Fair Work Commission has unpacked risk to health and safety in a 2014 decision called Miss SB. And this talks about the risk to health and safety, meaning the possibility of danger to health and safety. So important to note, you don't need actual danger to somebody, you just need a possibility of danger to their health and safety, and that includes to their mental health. The risk has to be real and conceptual. So there actually needs to be some tangible risk that you can latch onto. It needs to be, this is actually going to cause harm to this person, not, oh, there's a remote chance that if the person was to go home, turn left at the door, eat a carrot, do 360 degrees, look at the wall, in those circumstances, they might feel that there's a risk to their health and safety. No, it has to be a very real and concrete risk. And what we mean by risk is the exposure to the chance of injury or loss. So they don't actually need to suffer loss. It's just about exposure and possibility. So we're really looking at the conduct here rather than the impact it has on the individual. It's also important to note that the behaviour we're talking about doesn't have to be the only cause of the risk. It just has to be a substantial cause of the risk viewed in a common sense and practical way. Life is really complicated. Yeah, so people could be experiencing a whole different range of things that are causing them health issues or that are causing them to feel unsafe. As long as the bullying is a substantial cause of the risk that they're experiencing or the harm that they're experiencing, that's enough. So they don't have to say, bullying is the only thing in my life that's making me feel this way. It just has to be a substantial cause. A really important part of the definition of bullying is that bullying has to be repeated. So in that SB case we were just talking about, the Fair Work Commission found that it can't be a single incident. We need repeated behaviour for there to be bullying. And sometimes you'll see somebody make a claim that says, my manager had a stern discussion with me, I have been bullied. That won't cut it for the purposes of the definition because you need repeated behaviour. Now, there's no specific number of incidents that we pass through and can say, aha, the bullying definition has been triggered. There just has to be more than one occurrence. It also doesn't have to be the same type of bullying behaviour. So, for example, we talked about victimization before. We need more than one incident, but it can be more than one incident of different types of behaviour. So there might be an instance of victimization, then there might be another instance of isolation. So we have two instances of behaviour that could be bullying. I mentioned at the outset that it's really important to note there's a carve out from bullying for behaviour engaged in by an employer that's management action carried out in a reasonable manner. Reasonable management action carried out in a reasonable manner. I'm sure a lot of you have heard that term before. There's a thing that the government publishes when they're thinking of introducing legislation called an explanatory memorandum. And in the explanatory memorandum to the Fair Work Act, the government was at pains back in 2009 to make it clear that nothing in the Act was intended to prevent businesses making necessary decisions to respond to poor performance, and nothing in the Act was intended to prevent the way that businesses could direct and control the way work is given out to people, and where necessary to take disciplinary action. All the action has to be is reasonable management action carried out in a reasonable way. What does that mean? Helpfully, there's a case of Willis and Capital Radiology, which talks about what management action needs to be reasonable management action carried out reasonably for the purposes of the Act. And what that case said is that for management action to be reasonable, there needs to be some line of cause and effect between the conduct, behaviour or performance that the employer is complaining about and the relevant management action that's happening. The action also has to be reasonable and proportionate in response to whatever it is that the employee has done that's leading us to take this action. So you can't go a crazy way beyond what's reasonable. So if somebody's turning up late to work, you can't have a shouting match with them. You need to handle that in a reasonable way by, for example, saying, hey, you're late. What's going on for you? We need you to be turning up on time. Is there some way we can support you? That's an example of reasonable management action. We'll come to some practical tips a bit later on about how to ensure your management action is reasonable. But unfortunately, in some ways this is quite a good thing. What's reasonable depends on the entire circumstances of what's going on. So if you do find yourself in front of the Fair Work Commission arguing against a stop bullying order, which is something else I'll talk about, we'll be looking at the totality of the circumstances that face your business. So we're not applying a kind of artificial test here. We're really looking into what actually happened in your business to figure out whether your management action was reasonable. I really like this particular slide because I like to call it the why should I care slide. What is the impact of bullying? Why should we care about trying to prevent it? And you can see there that that's a pretty long list of consequences for bullying, both for your businesses and for the people involved. So the one at the very top there is that bullying creates a hostile and unpleasant workplace. It's just not nice, right? Nobody likes to be bullied. Nobody likes to see other people getting bullied. So it just creates a bad cultural environment at your workplace. And a bad cultural environment leads to a reduction in productivity and performance. Your people are thinking about something other than their job. They're either thinking, oh, I'm getting bullied, this is terrible, or they're thinking, oh, I've had a complaint made against me, this is terrible, or they're thinking, Jim has bullied Jake, isn't that terrible? They're thinking about something other than their job. And when we're talking about reduced productivity and performance, we're talking about money. You're losing money because your people are doing something other than what you've paid them to do. There's a formal consequence for this stuff. An individual who says they've been bullied can make an application to the Fair Work Commission for what's called a stop bullying order. The Fair Work Commission has a power under the Fair Work Act to order that bullying stop. What they can't do is order a financial penalty, so no money, but they can order anything else they consider appropriate, and that's a really broad power. So what we see the Fair Work Commission do typically is take a really practical approach to what's going on in the business and think about really practical solutions for how they might prevent the bullying from going on in the past. It's a really broad power. And as we'll see when we talk about Mrs. A's case a little bit later on, you'll see how practical the Fair Work Commission gets. The Commission's actually spoken about its view of this power, and they've said that they have a wide discretion in relation to the type of orders they can make, not simply stop bullying orders, but orders which have a rational connection to the jurisdiction. So basically, in layman's terms, what the Fair Work Commission is saying there is we can do anything we think appropriate except for ordering that you pay some money. So there's really a broad ability for them to make practical orders. Important to note, while I've said the Fair Work Commission can't make a financial order at that first point when they're issuing a stop bullying order, there are penalties for breaching a stop bullying order. So you go to the Fair Work Commission, you apply for an order, you get one. If the Fair Work Commission says, for example, you have to stop bullying and you don't stop bullying, you can be exposed to a penalty under the Act. And at the moment, the penalty is 60 Commonwealth penalty units, which is around $13,000. So not an insignificant amount of money for getting this wrong if you do have a Fair Work stop bullying order that you breach. Another consequence is increased absenteeism or presenteeism. People don't like coming to work in an unpleasant environment, particularly if they've been bullied. As I said before, bullying behaviour is distracting and unpleasant, and it causes stress and it makes people lose focus on their job. So if you're in a working environment where there's physical dangers around, you can see an increase in accidents because of this behaviour, because people are focused on something other than making sure they're safe at work. And on a similar vein, bullying can cause you retention issues or resignation. Some people will throw their hands up in the air and say, I don't want to be involved in this anymore, I'm just going to leave. And that's bad for a whole range of reasons, not just that you're going to lose people, but you're going to have to go through the expense and difficulty of recruiting somebody for their role. I like to remind people whenever I'm advising them on practical bullying stuff in the workplace, not to lose sight of the reputational damage that bullying behaviour can cause. You don't want to be a Google result as an employer who's had bullying take place at their workplace. It just paints a picture for potential employees and customers about the type of environment that you're offering. And the unfortunate thing about reputational damage is you can never really know what dollar value you can put on it, because you never know what business you might lose or what stellar employee might decide not to apply for a job because they've seen that you've had bullying occur at your workplace. This one is low down on the list. It's not low down on the list because it's not important. It's low down on the list because it's really the one I want to leave you with. This stuff can have really, really severe psychological and physical symptoms on the people who experience it and the people around them. And you can't underestimate the impact that this conduct can have on people. And in just a moment, we'll go to Brodies Law, which is a really terrible example of the worst type of bullying behaviour and how that can impact on people's lives. And I think I've made it clear that this stuff will cost you money if it's happening in your workplace. Money is important, but certainly not as important as making sure that you're providing a safe working environment for your people and for your customers. So at the risk of over-egging it, bullying is bad and it will lead to bad consequences for your people and for your business. So we want to stamp it out if it's at all possible and prevent it from happening in the first place. In Victoria, we've spoken about how the Commonwealth law definition of bullying applies. We have a slightly different position in Victoria, which I'd like to spend a little bit of time talking about because I think it's a really important illustration of why bullying is so important. And it's also one of the most severe consequences you can face as a business if you're found to have engaged in this type of behaviour. So we might have heard of Brodies Law, but where does it actually come from? Brodies Law is named after a young lady named Brodie Panlock, who was a 19-year-old employee of a cafe. You can imagine the situation, one of her first jobs, working in a cafe in kind of a retail fast food environment. She had a sexual relationship with one of her fellow employees, but over time, as things can, things soured and this male employee didn't reciprocate the infatuation that Brodie had with him, and he started to taunt and ridicule her. Brodie was subjected to relentless, demeaning and degrading behaviour from other employees in the workplace. Witnesses said that they messed with her mind. They called her a fat, stupid, ugly whore. Another witness stated that the company would have blood on its hands if this treatment didn't stop. The behaviour included pouring fish sauce over her, telling her to eat rat sack, pouring beer over her. So you really can't imagine how bad this would be. But when I'm saying it out loud, you kind of go, wow, I can't believe that this actually happened at a workplace. Brodie attempted to commit suicide. And after that happened, the employees ridiculed her again, saying that you can't even kill yourself properly. She was mocked again relentlessly, and two of the employees put rat sack in her bag, the implication being, try this. And she was subjected to having more insults and more beer and sauce thrown over her. Importantly, in this case, the owner of the cafe appeared to be aware of this behaviour and appeared to condone it by saying, for example, take it out the back. The implication there being, I don't mind if it happens, but I don't want it to happen in front of my customers. And tragically, Brodie did end up committing suicide. She jumped from a car park building and died in September 2006. So when I say that this behaviour can have really serious consequences, I mean the most serious of consequences. And this is why I said at the start, if anybody needs to take some time now just to refresh themselves, go and grab a glass of water, please feel free to, because this is really heavy stuff. But I hope it illustrates the importance of getting this right in your workplace. So if Brodie passing away wasn't enough, there were severe financial consequences for this business. The cafe owner was fined $250,000, and the three most responsible employees at the business were between them fined a total of $85,000. This was an action under the OH&S Act at the time, and they were some of the biggest penalties handed out under that act at the time. Brodie's family, quite understandably, didn't think that putting a monetary value on their daughter's life was enough, and they lobbied the government for what we now know as Brodies Law. And what Brodies Law is technically is an amendment to Victoria's Crimes Act, which extends the application of that act and the stalking provisions of the act to bullying behaviour. And what Brodies Law applies to is all forms of serious bullying, including physical bullying, psychological bullying, verbal bullying, and cyberbullying. It applies in the workplace, yes, but it also applies to bullying that occurs anywhere else in the community, such as schools, sporting clubs, on the internet, social networks, that kind of thing. Bullying is often characterised as a course of conduct that includes behaviour such as threats, abusive behaviour, offensive words and conduct, but serious bullying for the purposes of Brodies Law includes behaviour that is intended or could reasonably be expected to cause the victim to engage in suicidal thoughts or actions that involve self-harm. And the penalty under Brodies Law is up to 10 years imprisonment. So really quite serious, and a statement of intent from the government that this stuff will be taken seriously. And unlike some laws we see in Australia, where it's kind of a flash in the pan moment and we all get some good publicity out of it, this law is actually used quite a lot. In its first 5 years of operation, 58 people were charged with 140 offences against the law. So it's used around once a month in Australia. So that's troubling, because it suggests that bullying is quite prevalent in the community. And I guess it reinforces why, as employers and businesses, it's important that we understand what our obligations are to prevent bullying, and how we might discharge those obligations practically to make sure that we're doing the right thing by our workforce. It always gets me a bit talking about this, because it's just such a tragedy that this happened and that the law had to be changed to deal with this behaviour. But as I said, reinforces the seriousness of what we're talking about. So that's an example of bullying at the worst end of the scale. Let's now have a look at 3 examples of what you might call more common or garden variety bullying, something you might be more likely to see in the workplace, because while Brodie's case is severe, it's also pretty rare that you'll find yourself confronted with that type of behaviour. So the first case I'd like to talk to you about is Bailey and Peakhurst Bowling and Recreation Club. So Carol Bailey was employed as a casual bar steward by the bowling club for about 10 years in the late 90s to the late 2000s. By the time she left the workplace, she was 52 years old and had to cease work because of ill health. After she left her work with the bowling club, she brought a negligence claim against them, alleging that her employer had breached a duty of care. Important to note that there are a whole range of ways that bullying can be raised by workers, and one of them is by bringing a negligence claim. Here, the club actually accepted liability for what had happened and conceded that Miss Bailey's supervisor, Mr. Riley, had subjected her to concerted workplace bullying over a period of about 2 years. And the behaviour that Mr. Riley engaged in included constantly threatening Miss Bailey that she would lose her job, changing her work classification intentionally so that she lost pay and seniority, pressuring her to bend or break licensing rules, using extremely vulgar language, pressuring her to resign her union membership, and falsely alleging a shortfall in the bar finances when she was working, the implication there being that she had stolen money from the business. So it's worth pausing there, because you might hark back to that list of behaviours that might represent bullying. There's quite a few there, and we see that there's more than one. So we know that we have an example of bullying here because there's more than one type of conduct that's being engaged in. And it helps, I think, to see an example of something that happened in a real workplace, because you can imagine this situation. 2 people just don't like each other. One of them is more senior than the other and engages in this kind of behaviour, and that's how you get to a finding of bullying. In this case, the court awarded $507,000 in damages for future loss of earning capacity. Miss Bailey said, "I'll never work again because of this behaviour," including around $40,000 for loss of future superannuation. So again, quite serious financial consequences for the business. There were really poor policies and procedures in place in this company. So this case is a good reminder of the importance of good policy and procedure, which we'll come to in a little while, as a way to discharge your duty of care to your staff. The next case is NAB, the National Australia Bank, versus KDRV, another pseudonym. This worker attended regular weekly meetings with other team leaders and her manager, which were used to assess workloads for planning purposes. This staff member at these meetings was criticised for poor work performance, and the worker claimed workers' compensation, alleging injury after being continuously picked on and singled out by her manager and subjected to personal criticism in front of other managers. The worker's employer denied the claim, arguing that her condition was a result of reasonable management action carried out in a reasonable manner. And this is a great example of conduct that wasn't held to be reasonable management action carried out in a reasonable manner, because the meeting wasn't arranged for the purpose of discussing her performance. The behaviour didn't fall within the reasonable administrative action exclusion for a workers' compensation claim, and as we've seen, it's also an exception from a bullying claim. Because if you're going to discuss somebody's performance, you don't do that in front of their colleagues. You do it in a private meeting after giving them an opportunity to prepare. So you can see that that's an example of where a court has said that that management action was not carried out in a reasonable way. It would have been reasonable if you had had those discussions with her in private, but not in a meeting that was intended to discuss workloads and planning for the business. So it's important when determining if management action is reasonable, you have to examine the original intention of the action. So an informal, spontaneous conversation between a manager and a worker may not be considered management action, even if management issues are raised. So one of the key takeaways from this session, and I'll come back to this again, is document what you're doing in your workplace. If you're creating a contemporaneous record, and I'll come back to what that means because it's a term I really like, but it's a bit of a lawyer's term. That's a really good way to defend yourself against a spurious bullying claim if you have engaged in reasonable management action carried out in a reasonable way. The second last case I'd like to talk about is one that I mentioned before, the application by Mrs. A, another pseudonym. So the applicant, Mrs. A, and her husband were directors of a company that was engaged to provide management services to a residential complex, kind of a body corporate sort of arrangement. Mrs. A complained of bullying conduct, which consisted largely of excessive emails sent continuously by the president of the body corporate at all hours of the day and night. The respondent, the body corporate, argued that this conduct was reasonable management action underpinned by Mrs. A's failure to comply with her responsibilities as an employee. And what Mrs. A sought was a stop bullying order. And as I said, this is a fantastic example of a practical use of the law by the Fair Work Commission. So the Fair Work Commission looked at all the evidence here and found that, yes, the applicant's performance, Mrs. A's performance, wasn't up to scratch, and that the body corporate was entitled to take management action. However, they found that in sending many emails at all hours of the day and night, the respondent had engaged in unreasonable behaviour. So the management action carried out was not carried out in a reasonable manner. What the Commission ordered here was that the respondent, the body corporate, only send emails at particular times and only after trying to telephone Mrs. A to talk about the subject of the email. So a really practical way of short-circuiting somebody who's sitting at their keyboard firing off emails at all hours of the day or night. You've got to call her before you try and email her. Oh, I can't do that at 2 in the morning. I can only do that when her phone's on during the day. So that's a really great example of how practical the Fair Work Commission will be when they're confronted with an application for a stop bullying order. The last case is the case of Mr. Sun, and this is an example of management action that was found to be reasonable and carried out in a reasonable way. So Mr. Sun was an application developer, and Mr. A was later appointed as his boss. As part of the performance appraisal process, Mr. Sun had to self-rate his own performance. Mr. A, his new manager, queried some of those ratings, but eventually ended up giving him a meets requirements result for each of the aspects of his performance appraisal. Always good to move ahead one slide. I just foreshadowed where we're going to get to next, so you're welcome. On the day Mr. Sun received notification that his bonus, which was tied to the outcome of his performance appraisal, was going to be less than he thought it would be because he was expecting and exceeds requirements, he accessed his boss's electronic diary and found an email between his boss and his boss's manager regarding his performance. Mr. Sun collapsed at work after reading this and was taken to hospital. When he was well enough to return to work, there was a meeting to discuss his return to work, and Mr. Sun alleged that his collapse was work-related and that an unnamed person had changed the weightings on his performance appraisal. We'll call that the first complaint. His employer advised him it took that very seriously and ended up conducting a formal investigation and found that that allegation wasn't substantiated. So after that had all happened, Mr. Sun had a meeting with his manager to discuss his role and how it was going to be carried out in the future. And the manager informed Mr. Sun that the manager was entitled to allocate Mr. Sun certain tasks as he was his manager. Mr. A disputed this. He disputed that his manager was allowed to allocate tasks to him and accused the manager of bullying and took his employer to the Fair Work Commission seeking a stop bullying order. Here, the Commission was satisfied that the applicant honestly believed he was being bullied. However, in relation to the first complaint, the changing of his performance ratings, the Commission found that that didn't happen. So there was no conduct to attach a bullying claim to. And in relation to the second complaint, the manager bullying him by saying he could allocate work to him, it was found that this was reasonable management action and not bullying, because it was reasonable management action carried out in a reasonable manner. Think about the difference between the guy sending emails at all hours of the day and night and Mr. Sun's manager, who called him into a meeting at the workplace and discussed what he was going to talk about with him. Very different. So that's an example of where something is found to be reasonable management action. Some practical tips and responsibilities for you as employers, and these are all really kind of common sense things. We all have as employers, we have an obligation at work to take all reasonable steps to prevent employees or agents from discriminating, bullying, and harassing others. The really important word there is prevent. Our obligation is to get out in front of this kind of behaviour and stop it happening in the first place. It's not enough to be responsive. So how do you prevent bullying from happening in your workplace? The first thing you need to do is have a really good bullying policy in place. Make sure your people know what it says and what it requires from them. It needs to tell them what bullying is, what bullying isn't, and how to raise a concern if they have it, and then what will happen with their concern if they raise it. As with all policies, update it, keep it current, make it a living, breathing document. I hate nothing more than a policy that sits in a bottom drawer and gathers dust. It's useless. You may as well not have it, because when the crunch time comes, you're going to forget it's there. You're going to act in a way that's inconsistent with the policy, and that's never a good look. You've also spent time and money developing the policy, so make sure you use it. Ensure that you have a complaints process, and I'll talk a little bit more about that in a minute. Make sure your staff know it exists and that it's accessible. And really importantly, educate and develop the relevant skills within your management cohort. Your managers, as we'll see in a minute, are your best defense against this kind of behavior. They're out in the business and they're on the ground talking to your people. They know what they're feeling. They know what they're experiencing. Make sure they know what bullying is and make sure they know how to deal with it. This is a visual representation of the kinds of things I like to tell people to get their managers to do, because as I said, your managers are your best defense against bullying. They need to role model appropriate behaviour. Do not tolerate a manager who is a bully. They need to promote your organisation's policies by reminding their staff that they exist and sending them out to them and saying, hey, I'm just reminding you this is here, make sure that you have a read. They need to proactively monitor your workplace. That's really challenging in the current environment we find ourselves in, but your managers must take the time to make sure they know what's going on in the workplace. And you must take the time to make sure that your managers are reporting back to you about what's going on. This one's really important. Act if you see something inappropriate or unsafe, or if your managers do. You can't sweep this stuff under the carpet because it will only get worse over time. As soon as you see something happening, it's important to act in accordance with your policies and procedures and snuff it out. Encourage staff to discuss their concerns within your business. You want to have a culture where people feel that they're able to raise issues within the workplace, either confidentially or in a more public forum. If you have a culture of secrecy, people are going to hide stuff from you. And in my experience, the stuff that gets hidden is often some of the worst stuff, because it will get worse over time. And you won't have that opportunity to act when it's early on in the piece, and you can do something proactive and effective. The worse this gets, the harder it is to resolve. Prevent victimization. This is a policy question. Make sure that people understand they're not to take any adverse action against people who raise a claim. This will help people feel safe and encouraged to make a claim if they have one, to come forward to you and say, I think I'm being bullied. Deal with complaints seriously. I think Brodies Law and Brodies case give you a really clear illustration of how bad this can be. Don't be Brodies' employer. Take action, take it early, take it often. If you see this happening, you absolutely have to act upon it. If somebody is found to have engaged in bullying behaviour, take management action, give them a warning. If the conduct is serious enough and you've taken advice, terminate their employment. It's important not to sweep this stuff under the rug. I can't harp on that enough. And the last one, again, I like to leave it to the last because I think it's one of the most important, is induct and train your people. Make sure your staff know that bullying is not tolerated at your workplace. Make sure they know what bullying is and what it isn't, because oftentimes when it does come time to performance manage someone, you'll say, I have to have an awkward discussion with you, your performance isn't up to scratch, and they'll say, you're bullying me. If you've inducted them and made it clear to them that management action isn't bullying, it's a little bit less likely that they're going to raise bullying as a concern, and they'll be more likely to engage with you in the performance discussion. Just in the interest of time, I'll move through these very quickly. The presentation will be available afterwards if there's anything that you do want to go through. I always find it's helpful to do a little bit of internal reflection once you've sat through one of these sessions and really have a think about your workplace and how the things that I've spoken about today apply in your particular context. And the best way to do that is to ask yourself some questions. So I've developed this list of questions over time that really help businesses reflect on what's going on in their business and what's going on for you as employers. So are you aware of all the psychological hazards in your workplace? Do you know where your people might be at risk mentally and physically as well? If you did identify some inappropriate behaviour this very second, would you know what to do? Would you know what policy to reach for? If somebody complained, would you know how to deal with it, or would you have to reach for a policy? If your answer to either of those questions is, oh, I'm actually not quite sure, that's a suggestion that you need to either get a policy that will help you deal with it or refresh yourself in relation to what your policy says. As a manager, are you confident that your own style wouldn't expose you to a claim of bullying? How happy are you that you carry out your management action in a reasonable way? Think about your body language and tone. One of the things that we often see in a bullying complaint is it's not what people said, it's the way they said it. Sometimes you look at a bullying allegation in black and white and go, that doesn't seem that offensive to me. But then you hear how the person says it was actually said to them and you go, oh, I see where they're coming from now. So think about your body language and tone of voice, really simple, common sense things, but they can have a big practical impact. Think about whether you could be accused of playing favourites at work. We all have our favourite employees, but remember that isolation and assigning particular work to particular people or not giving work to particular people can in and of itself be bullying in certain circumstances. Never a good idea to play favourites because you do expose yourself to this kind of claim. Think about the culture at your workplace. Do you feel that everyone in your workplace has the right to decide if they're humiliated? Is anybody at your workplace regarded as being too sensitive? If you're thinking about people in terms of, oh, he's just a bit sensitive, that suggests you've got some cultural work to do in your workplace to make sure that people are taken for what they are, accepted for what they are, and that your workplace acknowledges everybody experiences conduct in different ways. What offends me might not offend you. It's important to think about everybody as an individual in the workplace. Do you talk about your values and policies at work, for example, at team meetings? Like I said, nothing worse than a policy that sits in the bottom of a drawer. It's a useless document. Unless you talk about it, unless you live and breathe your policy and the values that it represents, you may as well not have one. So make sure that you talk about your values as an organisation. We do not accept bullying here. I'm reminding you that we have this policy. Please take some time to refresh yourself with it. Sometimes people think of annual compliance training as a little bit of a joke. I actually don't think it is. I think it's a really good opportunity done well in sessions like this to remind your people that there are policies and procedures in place and to talk about these issues and to be honest and say, this might come up in our workplace. Here's what we would do about it. Do you make stereotypical judgments based on people's age, appearance, name, and religion? We all have our prejudices that come from our backgrounds and our upbringings. We really shouldn't bring those to work if we can all avoid it, particularly as managers, because when we start treating people differently, that's when we can find ourselves open to a bullying claim. So some final thoughts. What a whirlwind tour of a really complicated area and quite a challenging area. Some of the things that we've spoken about today are really quite confronting. And I hope that they make it clear and that I've made it clear that bullying is really, really serious and it can have really severe impacts, not just on your business, but on the lives of the people who interact with your business. While bullying is serious, it doesn't prevent you from managing your workforce. You're allowed to do that, but you have to do it in a reasonable and appropriate way. And one of the best ways that you can make sure that you can prove that what you've done is reasonable is by making sure you keep records of the way that you manage your staff. When I was a lawyer, nothing thrilled my heart more than a client who said, I've got a file note of the discussion we had. I had one client who pulled out a wrinkly old piece of paper from his pocket and it had, get milk at end of day written in the margin. And he said, "Oh, I'm sorry, this is a bit, it's not a great record." And I said, "I love that because it's authentic. Don't make stuff up. Keep an authentic record of the discussions that you're having with your people, because if they do turn around and try and say, 'I've been bullied at work,' you can say, 'Well, that's not what it says here. I've got a record of the discussion and this is what was said.'" The third dot point there, can't stress that enough. If this is bad enough, people will go to jail. The fines can be in the hundreds of thousands of dollars for the worst kinds of behaviour, and there's up to 10 years in jail. So important to get it right. That can all sound very scary when you think about jail time, but I hope I've also made it clear that if you understand what bullying is and you reflect on what your workplace is doing to prevent it, it's actually not that hard to protect your people and your business.